Welcome to the continuation of our lecture on affirmative defenses and privileges to intentional torts. This video, we are going to discuss the defense of self, the defense of others, and the defense of property. The defense of self attempts to balance two important principles: the rights of individuals to be free from harmful or offensive contact, and the right of individuals to protect themselves from harmful or offensive contact. Self-defense can be described as an affirmative defense to an intentional tort that is used when the would-be original plaintiff, that's the person that is asserting the privilege of self-defense, when that person is protecting themselves from harm. So self-defense is used as a defense, affirmative, when the would-be original plaintiff, that's the one who's asserting the privilege, is protecting themselves from harm. It's typically applied to intentional torts because that's what we are discussing, right? Intentional torts specifically that involve physical harm or the threat of physical harm. What would those torts be? And I know that if you thought about it, you would get here. What are the torts, intentional, that we've discussed that have some impact on your physicality, right? Have some impact, have some ability to cause some physical or offensive harm? That's going to be the intentional tort of battery. Self-defense is most often used to defend against a claim of battery. That is the intentional tort of assault, right? If A takes a defensive action in response to defendant X and A strikes defendant X, A may use that striking, right, as a self-defense claim against the assault. Make sense? So the person who is or would be the plaintiff, the person who's claiming defense, is taking some action to protect themselves from the action of the would-be perpetrator. Okay. The affirmative defense of self-defense, you're looking at, well, the intentional torts are usually battery, assault, or false imprisonment, because those three have the ability to have a physical impact that could be harmful or offensive to our physicality. Take a minute before we jump into the restatements. You know, this is my favorite part. So let's just make sure we understand. Intentional torts, defenses, all of them are affirmative. We've completed consent, and we're now going to take the trilogy of defense of self, defense of others, and defense of property. Currently, where we are is defense of self. Now, the Restatement Second of Torts, Section 63, discusses self-defense using non-deadly force. Restatement Second of Torts, 63, discusses self-defense using non-deadly force. Want to take an opportunity to explain that I am using the Restatement Second of Torts while our course book refers to the Restatement Third of Torts. The reason in this particular section, right, in this particular section, the reason that I am not relying on the Restatement Third of Torts is because for this particular section of the Third Restatement of Torts, it is still in draft form. In fact, the draft that our course book relies on is the fourth draft of the third restatement of torts, which was completed in 2019. So since the third draft for this particular section has not yet been released, my references in this video are going to be to the restatement second of torts, specifically self-defense that is non-deadly, that is found in section 63. And it states, the original plaintiff, that's the one claiming the defense, actually in the restatement, they call that person the actor. I chose not to use the term the actor because roles and statuses change, and it's very easy to get who's doing what to whom and what we call that, right? It's really easy to get that confused. So I wanted to be very clear as I was providing the information in this video. And so everywhere the restatement states actor, I've replaced that with the original plaintiff, comma, the one claiming the defense. Because if I say the one claiming the defense, that'll make sense. Oh, this is the one that's claiming self-defense. Got it. So the original plaintiff, the one claiming the defense, is privileged to use reasonable force, not intended or likely to cause death or serious bodily harm, to defend himself against unprivileged, harmful, or offensive contact, right? Or other bodily harm, which he reasonably believes is imminent. The original plaintiff, that's the person claiming the defense, is privileged to use reasonable force that's not intended or likely to cause death or serious bodily harm to defend himself against unprivileged, harmful, or offensive contact or other bodily harm which he reasonably believes is imminent. Yeah, imminent, right? What would be the expected rule statement from Restatement Second of Torts, Section 63(1)? Let's pull them out, right? This is what you all are learning how to do. I get these words in this beautifully written narrative sentence. How do I identify the pieces that are necessary for this rule of law, right? I tried to underline them, tried to give you a little bit of a hint. So let's pull them out, and we're going to extract a rule statement for self-defense. I did not extract a rule statement for defense of others, nor did I extract a rule statement for defense of property. I want you to practice the skill of extracting the rule statement, right, from the materials that you read. So if I extract the rule statement, what am I going to be looking for if I'm given a question about self-defense? I'm going to look for whether or not there's reasonable force that's being used. What do I mean reasonable? I'm looking at proportional force, whether or not there's reasonable force used, whether the force that I'm using is being used against an unprivileged contact. I'm using the force against an unprivileged contact, right? And that contact is one that is harmful, offensive, or that can result in bodily harm, yeah? It is reasonably believed by the actor, that's the original plaintiff, that's the person who's claiming the defense. It is reasonably believed subjectively, that means that the person themselves believe it, and objectively, which means that the belief is a reasonable belief, that the harmful or offensive contact is imminent. What am I looking for? Reasonable force, which is proportionate, unprivileged contact that is harmful or offensive, reasonable belief by the actor, that's the person who's claiming the privilege, that's objective belief and subjective belief that the harm is imminent. Got it? That's what we're looking for. Restatement second of Tort 63, let's look at comment G. Comment G, retaliation. The privilege stated in this section extends only to acts which are done for the purpose of protecting the original plaintiff, right? So I may be able to act in a way that otherwise may subject me to liability. That means I may be able to batter someone. I may be able to assault someone. I may be able to falsely imprison someone, right? Provided I use reasonable force to execute the defense, provided the contact that is made or anticipated, right, is unprivileged, provided that the contact is harmful or offensive, provided that I reasonably believe, that means objectively and subjectively, that the contact is imminent. Yeah? It cannot be a situation where I am retaliating in my performance of this battery or assault or false imprisonment, right, to something that has happened in the past. There must be a present imminent. There must be a present concern, right? There's got to be something presently happening. So it does not extend, the privilege does not extend to acts done as punishment, retaliation for past aggression, attempt at preventing aggression, or attempt at preventing repetition of aggression. So I can't use this to right past wrongs, and I can't use self-defense as a way of preempting, right? And right, I see in the future that this is the thing that you're going to do to me, and I'm going to exercise self-defense, which means I'm going to batter you now, right? So that you don't do this in the future. I can't use it that way. If the original plaintiff, that's the one who's claiming the defense, believes that the other, that's the defendant, that's the person who's executing the harm against them, if that person believes that the other's attempt to inflict bodily harm or offensive contact has been frustrated or abandoned, I no longer have that privilege either. What does that mean? That means that A is the aggressor and is threatening some harmful or offensive contact that's going to happen immediately to B. Okay? B sees it coming and gets ready to defend themselves. A, for whatever reason, changes their minds and says, you know what? I apologize. I don't know what got into me. And A abandons their aggression, right? A retreats from their aggression. A is no longer progressing in their intentional tort. B no longer has the privilege of self-defense, right? Why? There is no immediate threat. There's no imminent threat, right? If A has retreated, if A has abandoned their aggression and B decides that they're going to move forward in their air quote self-defense, well, B now risk themselves being on the wrong side of an intentional tort, right? So if the original aggression is abandoned, if the original aggressor retreats, we're done. You don't get to continue to pursue, okay? A good case, not for the change in status of aggressor, but a good case in present retaliation is the one that we talked about in class yesterday, and I couldn't remember the site. Here's the site. State v. Norman, 378 Southeast 2nd. It's a North Carolina case. Real briefly, the facts. Judy Norman was a battered woman. She shot and killed her husband while he was asleep. Okay, here's the background. Over many years, Judy suffered extensive physical, psychological, and emotional abuse from her husband, the man that she shot and killed while he was asleep. On the day that she shot and killed him, right, he had subjected her to a particularly severe episode of abuse, right? It was the worst of bad days. Despite that, Judy did not shoot him in the process of that abuse. She shot him while he was asleep, right? She's arrested. She's charged with murder. She pleads self-defense. Here's the legal issue. If we were to write an issue statement, and I set it up as the issue is, because it was appropriate to set it up that way. The key legal is, right, because I've got a couple of issues, and so I set it up. The key legal issue was whether Judy Norman could claim self-defense despite the fact that her husband was not an immediate, imminent, or active threat at the moment that she killed him. North Carolina trial court denied Judy Norman's request for an instruction on self-defense to the jury. They found her guilty of voluntary manslaughter. Judy Norman appealed. The North Carolina Appeals Court reversed, right, understanding battered women syndrome, and felt that she should be freed and that self-defense should have been an option for the jury to choose. The North Carolina Supreme Court reversed the appeals court. And they reversed the appeals court holding that Judy Norman could not claim self-defense because there was no imminent threat of harm at the time that she shot her husband, who was sleeping. What would the rule of law be from that case? For self-defense to be valid, the defendant must be facing an imminent threat of death or serious bodily injury. Well, this is self-defense using deadly force, right? But self-defense, even when we're not using deadly force, you must have an imminent, that's a present, that is an immediate threat. Okay? All right. Restatement second of torts, section 63, comment H. What is a reasonable belief? The privilege, that's the ability to claim self-defense, exists if the original plaintiff, that's the one claiming the defense, reasonably believes that the other, that's the aggressor, intends to inflict a harmful or offensive contact upon him, even though the other, that's the aggressor, may not have any intention to do so. Let me read it again. The privilege stated in this section exists if the original plaintiff, that's the one who's claiming the defense, reasonably believes that the other, that's the aggressor, intends to inflict a harmful or offensive contact upon him, even though the other, that's the aggressor, may have no intention to do so. What am I saying? Comment H of the restatement is saying the one claiming the defense can be factually mistaken. That's rather uncommon when we speak of intentional torts, right? But when we are exercising self-defense, if I've made a good faith mistake, I'm still allowed the privilege of self-defense, right? This means that the person defending themselves must believe subjectively that they are in danger of harm, and this belief must be objectively reasonable. Yeah, even if I'm mistaken. So I can either be mistaken or not be mistaken. Either way, I've got to believe me, myself. I believe, that's my subjective belief, that I'm in danger. And then my belief has to be reasonable. It can't be a hyper elevated sensitivity kind of belief. It has to be objectively reasonable. So here again, here's the first time where we've discussed a matter where we have to have objective and subjective reasonability. We have to have objective and subjective reasonability. Here's a good case. I told you guys I was going to send you some cases. Here's a good case if you want to read it. That's not in our course book, but it's a good case so that you can get a better understanding of objective and subjective reasonability. Here's the facts of the case. It's the People v. Getz, 1986 case out of New York. Mr. Getz, just one moment. Perfect, thank you. Mr. Getz shot 4 young men on a New York City subway after they approached him and asked him for money. Now, here's the history. Getz said that he believed he was about to be robbed, so he shot the men in self-defense. Getz had been previously mugged, right? And because he was previously mugged, he started to carry a gun for protection. What's the legal issue? The central, I have more than one issue. The central legal issue is whether Getz's belief that he was in imminent danger was both subjectively genuine and objectively reasonable. What do you think? Now, I know I didn't give you a lot of the facts, which is why I gave you the citation, and I'm encouraging you to go pull the case so that you can have a better understanding of how these words look when they are being worn by real people in real situations, right? We can look at the words on the page and say, okay, well, that makes sense. Those words make sense to me. This isn't rocket science. But when you go, right, when you go to apply it, when you're looking at a hypothetical, it's almost like, oh, what do these words mean? Go pull the case so that you can start to get a really good understanding. Yeah. But the long and the short of Getz, we get a subjective belief. Getz claimed that based upon his prior experiences with crime and being mugged, he genuinely, that's subjective, that's subjective. He genuinely believes that the men intended to rob him, harm him. It was genuine for him. That's subjective. Let's look at the objective belief. The court examined whether a reasonable person, that's objective, in Getz's situation would have also believed that there was an imminent threat of harm, which is objective. Even if Getz subjectively believes he's in danger, the law still requires an objective reasonability about it. Get it? So there's no, I'm hypersensitive, but you've got to believe it yourself. And that belief has to be reasonable. That's all a part of your analysis. The court's decision ultimately ruled that the proper standard for self-defense includes both the subjective and the objective belief. Yeah? Questions? Go take a look at Getz. It's a really, really interesting case. Non-deadly force continued. A valid claim of self-defense requires that the defendant have both subjective belief and objective reasonability about the belief. Okay? Restatement, second of Torts 63, comment I. What is the reasonableness of the original plaintiff's belief? The privilege, that's the privilege of claiming self-defense, exists when the one asserting the defense, right, reasonably believes that force is necessary. Force is necessary. The other's conduct, that's the aggressor, may put the original plaintiff, that's the one who's claiming the defense, in reasonable apprehension of bodily harm or offensive contact. Yeah? The acts or statements of other people, so we've got people outside of the one claiming the defense and the aggressor, the acts or the statements of other people may give the aggressor's conduct, right, threatening appearances, right? Once you put the aggressor's conduct in context, right, that might be enough to make a subjective belief in the actor's mind. The actor is the original plaintiff, that's the one who's claiming the defense, and may make it objectively reasonable to believe that harm is coming your way. Questions? No? I'm gonna stop right there, because that was a lot. And I want you to take a minute. Feel free to stop the video. Feel free to rewind the video. Feel free to start writing down questions, because the first thing that we're going to do in class tomorrow is cover any questions about the trilogy of defenses. And then, with whatever time we have left, we're going to move to necessity. All right? All right. Let's move on. The restatement second of Tort 63, let's look at comment M. The original plaintiff, the one claiming the defense's duty to retreat. There isn't one. I know. If you read the course book with the references to the restatement third of torts, that's in its fourth draft from 2019, which has not yet been published, might lead you to believe different. Pay attention. Restatement, second of torts, 63. Don't take my word. Take no one's word for what the law says. Don't take a judge's word for what the law says. Get the law and read it yourself, right? Restatement, second of torts, 63, comment M. There is no duty to retreat from the use of non-deadly force. That's the use of non-deadly force when we are discussing self-defense. We're done with self-defense. Woo! We are 29 minutes and 11 seconds in. This is a wonderful, organic place to take a break, stretch your legs. Still a little bit of sun outside, get some vitamin D. If you haven't been outside today, shame on you. Go walk outside. You might need some water. You might need an energy drink. Those things are not good for you. Go grab a piece of chocolate, whatever it is you need. Let's jump into defense of self, deadly force, right? Now we're going to do defense of self, deadly force. Restatement second of torts, section 65. Subject to the statement in subsection 3, we'll get to it. Right now, we're in subsection 1. Subject to the statement in subsection 3, an original plaintiff, that's the person who's claiming the privilege of self-defense, is privileged to defend themselves against another, that's the aggressor, by force. Slow down, because this is the one we've waited for. Intended or likely to cause death or serious bodily harm, right? When that original plaintiff reasonably believes that the other, that's the aggressor, is about to, and when they say about to, that means it's imminent, inflict upon them, that's the one claiming self-defense, an intentional contact or other bodily harm, and the one claiming self-defense is put in peril of death or serious bodily injury or ravishment, which can be safely prevented only by the immediate use of force. There are some intentional, I don't want to call them landmines, but there is some intentionality about this restatement that you must pay great attention to. Subject to section 3, we'll get to it. An original plaintiff, that's the person claiming the privilege of self-defense, is privileged to defend themselves against another, that's the aggressor, by force that is intended to or that is likely to cause death or serious bodily injury when they reasonably believe that the other is about to inflict upon them an intentional contact or bodily harm, and that contact is going to put them in peril of death or serious bodily harm or ravishment, which can safely be prevented only by the immediate use of deadly force. Restatement second of Torts 65, subsection 2. The privilege just stated, that's the privilege stated in subsection 1, exists, although the original plaintiff, that's the one that's claiming the defense, correctly, slow down, right? They have to correctly or reasonably believe they can safely avoid the necessity. Wait, what? The original plaintiff, that's the one who's claiming self-defense by deadly force, right? Can use that deadly force against the aggressor, right? Provided that the belief is reasonable and correct, that they can actually avoid using deadly force. So I get to use deadly force even if I can avoid using deadly force, provided that the aggressor is coming into my dwelling place. Some people call this the castle defense, right? A person's home is their castle. So if you are coming into my castle with the intent of causing me peril or serious bodily injury or ravishment, even though I don't have to, I can still use deadly force against you if you're coming into my dwelling place, right? Take a minute. I want that to really resonate. Because again, this makes an extremely narrow lane for you to use deadly force without having to ask them to cease, which is what you're going to have to do when you're defending your property, right? Or without retreat. My home is my castle. Got it? Subsection 3. The privilege stated in subsection 1 does not exist. The privilege stated in subsection 1 does not exist if the original plaintiff, that's the one who's asserting the defense claim, correctly or reasonably believes that he can, with complete safety, right? If I correctly and reasonably believe that I can, with complete safety, avoid the necessity of defending myself, then my privilege to use deadly force is gone, right? If all I need to do is to retreat or to relinquish. What am I retreating away from? Not my dwelling. If it's someplace other than my dwelling, and I know that I can completely safely get out of that situation, then I'm going to lose the privilege of exercising deadly force. It's not my home, and I know reasonably and correctly that I can escape that situation, that I'm supposed to escape that doggone situation, because it's not my house, right? It's not so connected to my existence, right? I gotta go, and I won't get the privilege. Or if relinquishing the exercise of any right or privilege other than his privilege to prevent the intrusion upon a dispossession of his what? Dwelling place. So if it's not my dwelling place, and if I know with reasonable belief, right? It's got to be correct and reasonable. It's got to be reasonable. Nobody's asking you to do anything unreasonable. But if you know that correctly and reasonably that you can get out of that situation without having to defend yourself, you can hide, you can run, you can teleport someplace else, right? Then you don't have the privilege of using deadly force. You're expected to run or hide, provided you can do that completely safe. It's got to be completely safe, and it's got to be a reasonable and correct belief that it's completely safe, right? If it's someplace other than your dwelling. Okay, restatement second of torts, section 65, comment A. What do we mean by serious bodily injury? They actually gave us the definition of serious bodily injury in restatement second of torts, section 63, comment B. So we're pretty familiar with serious bodily harm, right? Serious bodily injury. It's an injury that's so grave or that is so serious. Well, what does that mean? It's going to be fact intensive. If you want to look at this language and look at the illustrations that the restatement provides, you're going to have to go to section 63, which is self-defense by non-deadly means. Look at comment B to determine or to understand what serious bodily injury means. Why did they put serious bodily injury that only goes to deadly force in section 3 that talks about non-deadly force? I don't know. Let's get back to restatement second of torts 65, comment A. What is ravishment? Ravishment is being used to describe rape and any other form of carnal intercourse which is criminal in character. Okay, so that's what we mean by ravishment. It's not some old fogey term from a year ago. It has a present legal definition involved. Restatement second of torts 65, comment B. This section deals only with the privilege to use force intended or likely to cause death or serious bodily injury, right? So this is force that's intended or likely to cause death or serious bodily injury as a defense. As a defense. I'm not using force that's going to cause serious or bodily injury for any other reason other than to defend yourself from a proportionate attack. Restatement second of torts, comment F. The use of force intended or likely to cause death or serious bodily harm is not privileged merely to prevent a confinement. Right? So what do we remember when we talked about non-deadly force? I can use non-deadly force against a battery. I can use non-deadly force against an assault. I can use non-deadly force against false imprisonment. If we're talking about deadly force, I can only use that against a battery or an assault. I cannot use deadly force against a false imprisonment, right? Life is fragile and it's extremely important and it's worth protecting. So when we have laws that give you a privilege of harming someone seriously enough that they could die from it, you've got to know that these are supposed to be the most extreme of extreme situations. Okay. Restatement second of tort 65, comment G, standing one's ground. I do not practice law in Florida. I've already had this conversation. I am not doing any deep dives on Trayvon Martin. I said in class yesterday, I think that would be an amazing law review article for a law student. I think that would be an amazing law review article for even a professor who wants to talk about those types of laws and how this works and torts and criminality and how those worlds meet if they meet. But that's not what we're doing in 1L torts. But I encourage you to do the research. If this is something that interests you, see what transcripts you can get, see what docket notations you can get, see what pleadings you can get, right? If this is really something that you want to dig deep in, I encourage you to do that. I'm just saying we're not going to do it here. So what are we saying about standing our ground in basic torts? Comment G, in the interest of society, in the life and efficiency of its members, and in the prevention of the serious breaches of the peace involved in bloody affrays, requires one attacked with a deadly weapon, except within his own dwelling, to retreat. If you are not in your dwelling, restatement second of torts, section 65, comment G says, you are supposed to retreat unless you reasonably believe that there is any chance, no matter how small, unless you believe that there's any chance that retreat cannot be made safely. If you don't believe that retreat can be made safely, you are not expected to retreat. Talk about defense of others. All right, defense of others. Restatement second of torts, section 76, defense of a third party or third person says the original plaintiff, that's the one who is asserting the defense, right, of defense of others, is privileged to defend a third person, that's others, from a harmful or offensive contact or other invasion of their personality under the same conditions and by the same means as those under and by which she is privileged to defend herself. Yeah, it's really that simple. Defense of others. Here's the question. In that circumstance, the other that you want to protect, would they themselves be in a situation based on those circumstances where they could defend themselves? If they're in a situation where they could defend themselves either by self-defense, Section 63 of the Restatement Second of Torts, or either by self-defense involving deadly force, Section 65 of the Restatement of Torts, if they could execute under 63 or 65 and defend themselves, then you are privileged to defend them. Got it? I'm going to stop because that sounds really, really simple kind of compared to some of the stuff that we've just discussed. It's really kind of simple. I am going to intervene and I am going to protect Kathy, right? Do I have the privilege to protect Kathy? You're going to go through the analysis. Well, did Kathy have the privilege to protect herself with non-deadly force? Or did Kathy have the privilege to protect herself with deadly force? If the answer is yes, then I am privileged to protect her accordingly, either with or without deadly force, as those two things require. Really pretty simple, I know, right? Comment A, Restatement Second of Torts 76. Under this rule, the original plaintiff, that's the one who is asserting the defense, right, who intervenes for the defense of a third person, that's me intervening for Kathy, can use for that purpose only such means as she would be able to employ to protect herself, right? So again, deadly force only in circumstances of deadly force, right? Non-deadly force only in circumstances of non-deadly force. Okay. Who, well, is this one? Oh, mistakes, I'm still okay, as long as the mistake is reasonable. Who do I, the avenger, get to defend as a third party? Anybody. There was a time where the man could defend his wife or his child or his servant, right? And that was based upon some different beliefs and some different ideas, but right, it used to be that restricted. And then it got a little bit open if you're in the same family, and then it got a little bit more open if you're in the same household. At this date, we actually have a quote that says, "It may safely be assumed that at the present day, all such distinctions are obsolete, and every man has the right to defend any man by reasonable force." Yeah. So anybody, be real careful before you just jump in there though. Defense of property, we are coming around the bend. We are almost done. Hang in there. We're almost done. Defense of property. Restatement Second of Torts, Section 77. Defense of possession by force not threatening death. What is it saying? Non-deadly force. Okay. Non-deadly force. An original plaintiff, that is the one who's asserting the privilege of defense of property, is privileged to use reasonable force, not intended or likely to cause death or serious bodily injury, to prevent or terminate another's intrusion upon their land or chattel. So non-deadly force, reasonable force, right, to prevent or terminate another's intrusion upon my property, provided the intrusion is not privileged. What does that mean? utility companies who have an easement to come on your property, to get to phone poles, or to come on your property to read your meters, right? Privilege, right? So the intrusion cannot be privileged, right? The original plaintiff or the person asserting the privilege reasonably believes that the intrusion can be prevented or terminated, right? I can't just go out, and who would want to if you didn't think that you could reasonably prevent the intrusion or terminate the intrusion, but it's part of the rule, right? So the intrusion cannot be privileged. You must reasonably believe that your action to prevent the intrusion or terminate the intrusion will actually prevent the intrusion or terminate the intrusion by that level of force. And the original plaintiff or the person asserting the privilege has first requested that the intruder desist. The intruder must disregard the request before you can go forward to protect your property with non-deadly force. The only reason you don't have to first request for the intruder to desist and then see that the request is going to be disregarded. The only time that you don't have to do that first is when you believe that a substantial harm to your property or chattel will be done before you can request the desist and wait for a response. Otherwise, before you can defend your property or chattel with non-deadly force, you must first ask the intruder to desist, and you must give the intruder an opportunity to desist. If they don't, then go forward, right? And the only time that you don't have to do that is when you reasonably believe that there's going to be some significant harm or damage. Substantial is the way that the restatement says, before you can make the request to desist and give the intruder an opportunity. What about mistake? The privilege stated in this section exists if the one claiming the defense, that's the original plaintiff, right, is mistaken, provided that the mistake is reasonable. Again, the mistake has to be reasonable. And we're going to end with this case that we read last week, which was the Cotco v. Briney case. We've already discussed this case. This is the case where the husband and wife lived out somewhere where they have quite a bit of property. On that property, they have a house that is not being used as a dwelling. In fact, nobody's lived in that house in a really long time. That house was subject to being burgled regularly. And Mr. Cotco was really sick and tired of, Mr. Briney. Mr. Briney was really sick and tired of the house being burgled. He went in and he set up a shotgun so that it would shoot remotely. Cotco came in, he burgled the place. He went to the bedroom where the gun contraption was set up. He opened the door. He lost half of his leg. Literally, read the case. He lost half of his leg. Was he guilty of larceny? He was. And he was actually found criminally guilty of larceny. And he actually served time for that crime of larceny. But protecting whatever old jars of fruit or whatever was in that abandoned house did not justify the damage to life or limb, right? So there's a message here. Our stuff may be important, but it can never be more important than somebody's life. Yeah. And I think we are done. Here's a summary of the defenses. You know who I am. I like tables. If this table works for you, use it. If this table doesn't work for you, forget that I made it or make your own table. If you have any questions, write them down. Review the video, review your reading, right? This is really pretty straightforward. What I would like to do tomorrow is start necessity. But if you've got legitimate questions, and we're going to talk about the questions, and if we have time left, we'll get to necessity. If we don't have time left, that's fine. If we're asking real questions, if we're addressing real issues, not a problem. We'll start necessity on Monday. Either way, read the cases that we have listed for necessity so that if we have a chance to start tomorrow, we'll all be prepared. Be safe, have great fun. God willing, I'll see you all tomorrow.